Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar titled, What is the Duty of an Employer to Prevent Bullying and Harassment? My name is Hannah Staunton. I'm a lawyer at WorkCover Queensland, and I'll be your host for today's webinar. Before we get started, I'd like to acknowledge and pay respect to Queensland's elders past, present, and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters, and community. Today's webinar will run for approximately 1 hour. If you need to leave a bit earlier, this session will be recorded and we will send a link to the recording out via email early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Now, I know a lot of you have already submitted questions ahead of this webinar. Please also feel free to submit any questions during the webinar using the panel on the right-hand side. We have a very jam-packed webinar presentation for you today, but if we have time at the end, we'll aim to answer some of your questions. I'd like to introduce our guest speakers for today's presentation. First, I'd like to welcome guest speaker, Assistant Crown Solicitor Edward Zappert. Ed has practiced exclusively in insurance litigation, including workers' compensation, public liability, and professional indemnity. And our second presenter for today is Senior Principal Lawyer Andrew Hall. Andrew provides specialist legal advice and representation to WorkCover Queensland in defence of common law damages claims for work-related injuries. A warm welcome to both Ed and Andrew today. I'd just like to remind our listeners today that our webinar is focused on common law. If you are looking for information relating to mental health in the workplace more generally and from a statutory claim perspective, please definitely head to our WorkSafe website, as there is a whole wealth of information contained under the safety and prevention and then the mental health tabs. Please also note that any advice given or questions answered today by either Crown Law and/or WorkCover Queensland is general information only and should not be taken as legal advice. I will now hand the webinar over to Ed to begin the presentation.
Thank you, Hannah. The past number of years has seen a significant increase in damages claims made by employees alleging pure psychiatric injury. And what I mean by that is, rather than someone having a physical injury such as a broken leg and then suffering a psychiatric condition such as an adjustment disorder, the main injury, the subject of the claim, is a psychiatric injury. Now, employers have a significant degree of trepidation about what those claims mean and why they are at risk from them. Now, I think this is at least partially because they involve questions of personality and emotion and the interaction of various people with differing personalities and levels of emotional maturity. Employers are frequently required to manage employees who would not, in other circumstances, socialise together. They may not click. They may even actively dislike each other. What then is the duty of an employer to prevent bullying within the workplace? Now, I'm going to, as an overview, I'll hand over to Andrew Hall to provide an overview of what we're going to do today and a short summary of the law in this respect.
Yeah, great. Thanks very much, Ed. What we're planning to do in the presentation today is give a brief overview about how common law damages claims for psychiatric injury are viewed by the courts. We'll talk about some of the general principles involved, including when a duty of care will arise and some commentary on what that involves. We'll then go through a number of specific cases involving allegations of bullying and how those are dealt with by the court, and also some lessons on what employers can learn from those specific cases. Now, courts approach psychiatric injury is different to physical injuries. A big difference is that there is a duty to prevent physical injury owed to classes of persons, whereas a duty to prevent psychiatric injury is owed to a particular person. Now, that may sound rather abstruse, but it's a significant difference from a legal point of view. The main case about this was decided by the High Court in Kohler versus Kerebos. The High Court said that when looking at whether there's a risk of psychological to an employee and what that the response to that risk should be, the starting point needs to be, number one, what were the duties that the employer and employee agreed the worker would be performing in the contract? And secondly, if the employer is on notice of any particular risk of psychiatric injury to that particular employee. So that's the particularity I referred to earlier. The requirement of the employer being on notice is critical to the existence of a duty, and what must be foreseen is the risk of psychiatric injury, not merely stress. That is, it must be foreseeable that there is a risk of a worker developing a diagnosable psychiatric condition, not merely the stress that goes hand in hand with most workplaces. Generally also, it's clear that employers are not under an obligation to provide a happy workplace. Quite obviously from ordinary interactions, you can't guarantee how people will bounce off each other on a day-to-day basis. Employers aren't expected to solve the human condition. Now, turning to bullying specifically, if there is bullying in the workplace, it doesn't automatically mean an employer will be liable. And as I've also said, an employer is not required to guarantee that the workplace will be happy. Then from the employer's point of view, what is the problem? The answer to this is the definition of what sort of conduct could be considered as bullying. In some different circumstances, it might mean an employer is liable, and in some cases not liable. A key issue will be what signs and symptoms a particular employee might exhibit, whether the employer takes notice of those signs and symptoms, and if so, what is the risk? What all this means is that there are no hard and fast blanket rules which you can take when looking at these cases. I'll just hand you back over to Ed, please.
Yes, now in terms of bullying, there's generally two different bases that an employer might be liable for bullying. There is bullying that falls within the scope of employment and bullying conduct that falls outside that scope. So bullying within the scope of employment would be conduct such as managerial mistreatment and harassment. So this would generally entail the perpetrator performing the role of a manager in an inappropriate way. In those circumstances, there is the potential for the employer to be liable for the conduct itself of its manager, and that's called vicarious liability. There is also the potential for the employer being directly liable for failing to prevent that conduct. The other type, and that's the type of bullying we deal with in most cases. There is other types of bullying, which is the bullying that falls outside the scope of employment, and that would be such things as sexual harassment, abuse, and the belittling and harassment of co-workers when that's not part of it. When managing those workers is not part of your duties. Now, the employer is unlikely to be vicariously liable for that conduct because by its very nature, it's outside the scope of the duties an employee performs. But if an employer does not have an appropriate policy or procedure to deal with complaints, and should a complaint not be dealt with appropriately, there's the potential for an employer to be directly liable for failing to deal reasonably with the conduct once it is put on notice of it and of the risk of injury to the employee. The factors the court takes into account when determining breach, they're essentially those factors set out in section 305 capital B of the Workers' Compensation and Rehabilitation Act 2003. Generally, it's, look at the risk, and in the circumstances, a reasonable person in the position of that person would have taken some precautions. Now, I'll now go down to a number of the cases. These cases involve conduct where both the cases involve material where both the plaintiff and the defendant were successful. They involve instances of conduct occurring over significant periods of time, and there's also a case involving a single instance of conduct which has been characterised as bullying. Now, because the duty is owed to a particular person, the cases very much depend upon their different facts, and also because of this, they are very fact heavy. And as the conduct occurs over a significant period of time, sometimes it can be a bit dense in terms of the material. Some of these cases the judgment runs to over 100 pages, and the cases themselves were heard over anything up to 2 weeks of court time. I've tried to distill them down as much as I can. Now, the first case is Robinson and Lorna Jane. Now, that was a case in the District Court at Brisbane. The plaintiff was employed by Lorna Jane for 20 weeks and alleged that she was bullied in various ways by the Learning and Development Manager to whom she reported. The plaintiff alleged that Lorna Jane was directly liable for her bullying, for her supervisor's bullying, as well as being vicariously liable. She alleged that as a result of the behaviour, her pre-existing personality disorder was triggered, and that if the supervisor had received appropriate workplace warnings and counselling, she would have ceased her conduct and the plaintiff would not have suffered the psychiatric illness. Now, we talked before about the employer having to be on notice that the plaintiff is at specific risk. The plaintiff in this case alleged that Lorna Jane was on notice based on two specific events, an email of 23 August 2012 and a meeting of 29 August 2012. The particular email was sent by another co-worker who had resigned. In that email, the co-worker praised the plaintiff and complained about the manager. The email went on to note that she'd resigned because she could not continue to work for a company that uses, and I quote, scare tactics, intimidation, favouritism and bullying in the workplace, close quotes. Very importantly, that email did not allege that the manager had done those particular things to the plaintiff and did not particularise any particular acts that the manager had taken. Now, in the meeting, the plaintiff said that she complained about being unfairly treated, bullied and harassed, and the plaintiff said that they discussed that email in some length. Now, the evidence of the manager involved in the meeting was someone from Lorna Jane's Human Resources Department. That evidence was quite different. Her evidence was that they didn't discuss the email in detail at all, but they simply discussed whether there was any issues or concerns which the plaintiff had at the store. And importantly, that manager gave evidence that the plaintiff was neither complaining nor was she distressed or tearful. Now, the judge found that Lorna Jane was not on notice of any poor behaviour by the manager in respect of either the email or the meeting. In respect of the email, it expressed opinions without any details or facts and was simply written by an unhappy employee who was resigning. It was noted that there might be many reasons why an employee might be tearful after an interaction with a supervisor. And in respect of the meeting, the trial judge simply accepted the evidence of the Human Resources Manager over that of the plaintiff. And that was because in this particular instance, he found the plaintiff that was not a credible witness. Numerous matters were raised during the course of the trial, indicating that the plaintiff had lied about significant matters, including her employment history and the effect of her injuries on her social life. Rather than being an instance of bullying, the judge found that following the meeting, the manager organised extra training for the plaintiff, took steps to follow her up about her request about roster flexibility. And in addition, the plaintiff had a number of medical attendances around the time of the meeting. During those medical attendances, she made no mention of any tearfulness at the meeting or any conduct of the meeting that could be considered bullying. There was also another issue that the particular manager had made some posts on her private social media page, which the plaintiff said denigrated her. She called her a generator. Now, the manager gave evidence that what she meant by that, well, the Facebook post says that generators were people who generated problems. And there was her new name for people that she despised. Those posts were on her personal Facebook page, and they did not expressly identify the plaintiff as a target of the remark. Lorna Jane somehow became aware of the posts, and the manager took them down. Lorna Jane, despite the fact that they're on a private Facebook page, Lorna Jane implemented its social media policy, took disciplinary action against the manager, removed that particular store from her control, and arranged for the plaintiff to report to a different manager. The posts themselves were made in a private capacity and were not matters for which Lorna Jane could be vicariously liable, but the action taken in respect of them was reasonable. And this is a case where the defendant was successful. The particular decision is of limited value in determining what steps an employer can take, because the plaintiff was simply not a credible witness. She was disbelieved on all important points. But what it does show is you cannot protect yourself from a claim. A vulnerable individual can have various perceptions of conduct, which, although once you analyse it is reasonable, may not seem reasonable to him or her at the time. If you wish to take anything from this case, it is that credibility is important. And to be credible as an employer, you need to act in accordance with your procedures. And Lorna Jane did that. As I said before, they identified the potential for injury, they disciplined the manager, and she was no longer managing the plaintiff. And the fact that the anti-bullying policy was complied with so readily and in a timely fashion no doubt enhanced the credibility of Lorna Jane in the trial judge's view. Had they failed to take that action, there was the distinct possibility that they may have been regarded to have been on notice from that point of the potential for bullying of the plaintiff by the employee, and things may have ended differently. Now, the next matter is a medical matter, the matter of Robertson versus the state of Queensland. Now, the plaintiff here was an enrolled nurse. She was at the Gold Coast Hospital. She had been an enrolled nurse since 2006, and she'd worked night shifts in the cardiology unit since 2008. She claimed that during 2011 and 2012, she was badgered, bullied, and mobbed by colleagues at work, most of whom were registered nurses. There were multiple incidents which were alleged to be bullying. Now, as with the Lorna Jane case, most of the plaintiff's evidence here was rejected, but the types of incidents, and I've tried to reduce them as much as I can, but there were multiple incidents, but they included an incident where she was not offered comfort following the death of a patient, an incident where she was accused of incompetence as the result of drawing up an extra unit of insulin, an incident during her yearly performance improvement plan meeting where she was asked when she expected to retire, an incident during a handover when a registered nurse interrupted her and made her feel humiliated, an allegation that she was abused and threatened by a nurse when she refused to perform observations for that nurse. There are quite a few more that I won't go through, but ultimately the trial judge dismissed all of those allegations except two. He found that out of the multitude of complaints, there were only 2 instances of conduct which could possibly rise to the level of bullying. In respect of the incident involving the appropriate dosage of insulin, the plaintiff was told by a registered nurse that if her eyesight was okay, then she was just incompetent. And the other incident was one that occurred where a particular nurse did not like the plaintiff and had serious doubts about her overall competence. The unacceptable conduct included that nurse waving her hands, aggressive questioning of the plaintiff. Importantly, the court found that the conduct was not bullying or badgering, but could have been if combined with other incidents of a similar nature. Ultimately, the trial judge found that all of the supposed bullying and badgering was because of the perception of the plaintiff. It was held that the defendant and its employees held serious and justified concerns for the competency of the plaintiff, and they raised those concerns in an appropriate manner, even though at times raising those concerns involved raised voices and some stress for the plaintiff. That was not bullying. Further, the court found that not only was the conduct not bullying, but all of the allegations raised by the plaintiff did not put the employer on notice that the plaintiff was at risk of psychiatric injury. Even though it was clear the plaintiff was feeling unhappy in working with some of the other nursing staff, those matters alone did not give rise to a risk of psychiatric injury as opposed to merely unhappiness. And it was also important that the plaintiff did not complain to anyone at the hospital that she was being bullied. She did not engage the hospital's bullying procedures. Had she made such a complaint, and this was noted by the judge, the hospital would have needed to investigate them. It may have subsequently found that they were not feasible, but they would have needed the investigation. Now, a critical lesson that we need to learn from this decision is the fact that a duty owes is a personal one. The trial judge referred to those a couple of High Court decisions and found that the difference is, and he called it the critical factor, in the case Andrew referred to of Kohler, the employer had no reason to suspect that an employee was at risk of injury. However, the judge referred to a different decision of Eaton, where the deterioration in the psychological state of a nurse was readily apparent during the period in which she was mistreated, and no such deterioration was apparent in this case. A major lesson from this decision is that an employer is perfectly entitled to investigate, question, and ultimately, if necessary, take remedial action in respect of an employee's competency, as long as the way in which they do so is by appropriate methods. That is, by using the employer's own procedures, not singling out the employee, and making sure that any investigation is conducted in the same way for that particular employee as it is for others. And the final lesson from Robertson is that just because there are a high number of allegations does not make them more significant if ultimately they all turn out to be unremarkable. Now, as I said in Robertson, the defendant successfully defended that matter. And I'm now going to a matter which you should contrast to Robertson, because it again involved a hospital, but in this case, the plaintiff was successful and she was awarded over $1 million. While I'm going through the facts, have a think about the type of conduct which was alleged in Robinson and the action taken as opposed to the conduct here. Now, in Robinson, there was the District Director of Nursing for the Cape York Health Service. She alleged that between March 2010 and January 2017, she was subject to management action by the District Chief Executive Officer, who harassed, mistreated, devalued and undermined her. The plaintiff was successful and the court found that the employer was vicariously liable for the CEO's conduct. And I won't quote from judgments much in this talk, but I will quote from one here. The judge found that the greater the authority in which an employer clothes an employee, the greater the risk of harm flowing from conduct abusing that authority, and the easier it is to infer that the conduct was done in the course of employment. The authority entrusted to the CEO and the fact that all of her conduct was carried out in the performance of her role compelled the inference that the defendant was vicariously liable for it. Now, my best summary of the factual analysis there is as follows. The plaintiff was an experienced nurse. She was the Director of Nursing at the Health Service, and she was accountable to the district CEO, and she was responsible for directors of nursing based at various Cape York towns and communities. There were significant conflicts between the Director of Nursing at WEPA and WEPA's nurse unit manager. Both of those persons complained to the plaintiff about each other. The plaintiff consulted with various people, and as a result, the employer arranged for an external agency to write a report. That report indicated there was a long history of interpersonal difficulties between the nurse unit manager and the Director of Nursing. It suggested that the nurse unit manager was effectively a troublesome employee, was unpredictable, inconsistent, and it recommended the removal of the nurse unit manager. And as a result of that report, the nurse unit manager targeted the plaintiff, even though she had been, as a result, she was assigned to a different work unit. Now, all of this happened prior to the CEO in question arriving in January 2010. And importantly, on arrival, she was told by the plaintiff of the dysfunctional nature of the relations within the unit, and she was told that the plaintiff was vulnerable because of those behaviours. And in particular, she noted that the vulnerability arose because of the personal attack of the nurse unit manager. When she arrived, the report into the nurse unit manager had not been actioned in a number of relevant details. There were a significant number of recommendations, including formal performance management and disciplinary processes that had not been undertaken, and the CEO did not undertake any of those steps to ensure that those matters were attended to. And after that, the particular nurse unit manager then submitted 8 injury forms alleging that the plaintiff had in fact bullied her. Ultimately, it was found that all of those complaints were ridiculous, vindictive and vexatious. Notwithstanding that the CEO knew that these complaints were vexatious, she endorsed them and referred them for independent investigation. She didn't tell the plaintiff about them, and the plaintiff didn't find out about them until some months later. The court was scathing about these reports. It said it was self-evident that of the incidents, they were They'd either preceded the consultant's report or they were trivial, and no disciplinary action was instituted against the nurse unit manager as a result. Later, that same nurse unit manager lodged a formal grievance against the plaintiff, and it took 2 months for the CEO to engage an appropriate organisation to conduct an independent review. The grievance made specific allegations that the plaintiff was responsible for unfair treatment of the nurse unit manager. The judge found that it was verging on surreal that the CEO incurred the expense of an independent review into an earlier independent review in response to a complaint about earlier independent review that the CEO knew to be manipulative and vexatious. And he said it was difficult to avoid the impression that despite the toll that she knew this was having on the plaintiff, the CEO was simply unwilling to firmly deal with a troublesome employee. There are a number of different events moving forward, and by December 2010, it appeared that the plaintiff, had become the victim of bullying by Turner herself. She sent an email to the Human Resources Manager alleging that she was constantly having to deal with complaints about the plaintiff's behaviour and complaints about how the plaintiff had managed a number of staff. And the court found that the CEO was prepared to completely misrepresent the truth about the plaintiff's conduct. Now, the plaintiff subsequently left the employment. The court found in her favour, and she was awarded over $1.4 million clear of the work cover refund. Now, what did the court say that the failings were? There were 2 broad categories. The first was the unreasonable failure to investigate the nurse unit manager's workplace injury forms and the failure to investigate a later injury form lodged by the plaintiff. The court found that the risk of psychiatric injury to the plaintiff was reasonably foreseeable because of the signs being progressively exhibited by her and her increasing degree of emotional concern and distress. The employer was required to investigate the matter, but to do so in a timely and determinative way. A reasonable employer would have understood that its response to complaints bore heavily on the probability of any injury occurring. The second broad category identified by the court were the repeated instances of managerial mistreatment of the plaintiff from the CEO herself. And those occurred in circumstances where the CEO had clearly been on notice of the potential for psychiatric injury of the plaintiff. The court said that isolated instances of managerial mistreatment could potentially be a breach of the duty, but repeated behaviours are obviously worse, and all of those behaviours occurred in the course of the CEO managing the plaintiff. Now, what are the lessons we can learn from Robinson? The contrast with the Robertson decision is instructive. In Robertson, there were justified concerns for the competence of the employee. Those concerns were appropriately investigated and remedial actions were taken. However, in this case, Robinson, the employer was on notice of the risk. Allegations were made that were clearly vexatious, and they were not investigated, they were allowed to drift and were never effectively dealt with. It appears that in Robinson, a reluctance to deal with a difficult employee ultimately led to the victim of that employee's conduct becoming a further victim of harassment by the manager, unwilling to take difficult action. So the lessons we can learn are: failure to take difficult action can lead to a much greater problem. The failure to investigate complaints in a timely manner clearly has the potential to put an employer at risk of breaching its duty. And the fact that a complaint is vexatious does not mean it should be ignored. Indeed, the prospect of a vexatious complaint hanging over an employee's head is more likely to cause psychiatric harm than one that is either justified or at least potentially justified. I'll now move on to another case where a plaintiff was successful, and that's a matter of Keegan and Suzanne Corporation. Now, this claim involves an assistant store manager who was bullied over 11 days after returning to work from maternity leave and encountering a new store manager. Now, the new store manager that had been hired had never worked in retail fashion. She'd worked in a jewellery store. even though when a reference check was conducted on her, the jewellery store advised that they would not employ her again because she needed to learn management and people skills, Suzanne still employed her. The store only had a small complement of staff, and there were only ever 2 or 3 people on the roster at any given time. In her first 3 days of returning to work, the plaintiff received criticism about the state of the store, not signing customers up to the VIP program, poor handwriting, failing to remove security tags, not mopping the floor. Despite this, on the 3rd day after returning to work, she spoke to the Queensland business manager of the employer and told her that working with the manager was good. However, things changed the next day. The manager essentially got in her face. She held a mop to her face, challenging her for complaining about the condition of the mop, repeatedly spoke to her in an aggressive and nasty tone. And at the end of that day, the plaintiff telephoned the manager back and revealed the truth about how she'd been treated. Importantly, the manager's response was not to engage Suzanne's bullying procedure. The manager, this is the state business manager, rang the manager of the store, told her what had been said, and just asked her to be a bit more careful with the plaintiff. You can guess what happened then. By the 11th day, the plaintiff telephoned the manager again, reporting concerns about the conduct. It hadn't abated. That manager's response was to tell her she was going to have to work it out for herself. The plaintiff didn't return to work. Now, Suzanne had a bullying policy which specifically defined both bullying and harassment, and the store manager's conduct fell within those definitions. The policy made it clear that line managers and supervisors were responsible for treating all complaints seriously and taking immediate action to investigate and resolve any such reports. And it was indicated that confidentiality would be respected at all times. Now, the court found that the manager's dealing with the complaint was inconsistent with the policy. In particular, on the 4th day when the plaintiff telephoned her in tears, complaining that she was being bullied, this was a pivotal point. The fact that a crying employee complains of bullying conduct over the phone provided signs of the plaintiff's distressed state of health. And importantly, specific details of the conduct were provided. The court held that from that point, the employer was on notice of the risk of psychiatric injury. Now, here, once they were on notice, breach was inevitable as they hadn't complied with their own policies. The court accepted that complying with the policies would not necessarily ensure mental well-being for an employee complaining of bullying, but held that it would likely assist and that proper investigation and disciplinary action likely would have prevented its recurrence, and proper support for Keegan would have likely avoided further distress to her. Now, the court went on to note that a reasonable person in her position would have realised its ongoing failure to address the complaint considerably heightened the prospect of her emotional distress worsening. So what's the lesson from this decision? The clear lesson is that if there is a complaint of bullying, then it is not sufficient to take some informal management action. The organisation, if they have a policy and procedure, you need to follow them, and you need to follow them impartially. A failure to follow the company's own procedures may lead to circumstances where, had the conduct been investigated, it might have either been determined that it wasn't bullying, or it could have been easily ameliorated by some sort of management action. However, if you don't undertake the process, you then lead to a situation where you've been notified that there's potential bullying, you know that the person is under stress and at risk of injury, and the fact that you don't investigate properly can lead to a situation where the employer is liable in circumstances if they'd simply gone and done the investigation, they would have fulfilled their duty. Now, I'd now like to hand over to Andrew, who's going to go through a number of cases of bullying, in particular, the matter of Walters, which involves a single instance.
Yeah, thanks very much, Ed, and that's really impressed about the way you managed to compress the complex fact situations into a relatively short space of time. I'll try to follow your lead. Yeah, the 3 cases I've got to discuss, Ed's talked about a couple of situations in retail, in health, etc. I'm going to be looking at cases involving a community care situation, a university, and a university bookshop. The first, as Ed mentioned, is Walters. This was a case in where the plaintiff was successful. It's a Queensland case. Now, in cases such as Robinson, the alleged bullying took place over several years, while in Keegan, it was a matter of weeks. Generally, in order for there to be bullying, the behaviour must be unwelcome and repeated. That makes a lot of sense. We're all human beings. We're not our best selves at all times and under all circumstances. Even the most even-tempered boss may lose their cool on a bad day. Isn't that right, Ed?
Not me.
No. Courts understand this. However, the next decision shows that in certain cases, a claim for bullying may be successful even if there's only a single episode of bad behaviour. Ms. Walters was employed as a security guard at the University of Sunshine Coast. She was a well-regarded worker. Her supervisor, Mr. Bradley, held the position of Director, Capital Programs and Operations at the university. He came from a construction industry background and had the reputation of being a hands-on manager. On a particular day in March 2008, early in the morning, there was a power outage on the campus. Ms. Walters was on her normal patrol duties when this occurred. A fire alarm apparently had gone off elsewhere in the premises, and the company which monitored the alarm system called to check if there was a problem. Walters took the call. She sat down in an office and took notes of the call, as she was required to do. Bradley found out that she was not at her usual post. He reacted badly. Without asking Walters what she was doing, he rushed towards her, waving his arms and screaming, "Get out of there." He was saying things like, "What the hell do you think you're doing in there? There's a power outage and you're in there." Walters was frightened by the experience. Bradley apparently was a big man. Walters had worked as a security officer for quite a while, and in a previous role with Qantas, had to put up with being yelled at by cranky passengers. However, Bradley's behaviour, she felt, went beyond anything she had dealt with in the past. Now, as it turns out, Bradley had formed for this sort of behaviour in the workplace. A few months earlier, he had treated another employee, Heather, to similar aggressive behaviour. This had been the last straw for Heather, who never returned to work afterwards. She lodged a formal complaint of workplace harassment and bullying against Bradley. She alleged that he had yelled at her, waved his arms, gone red in the face, and threatened her position. Now, when the matter went to trial, or even at the time, the university did not dispute these allegations, and it reached a separation agreement with Heather, which included a separation payment. She never withdrew her complaint against Bradley, nor did she request the employer not to investigate it. However, it simply lapsed when she left. Now, this was only a month before the incident when Bradley had his confrontation with Walters. So the court concluded that well prior to Bradley's confrontation with Walters in March 2008, the university knew that Bradley had verbally abused Heather, behaved in a threatening manner and threatened her job. It also knew that the incident with Heather had caused her a workplace injury because she had lodged a workover claim for stress as a result. The court looked at what the employer had done to address Bradley's outburst towards Heather. Apparently, it had adopted a low-key approach. The university's vice-chancellor met with Bradley and explained that raising his voice was not good management style, and that other people's perceptions of what he was doing were just as important as his perception of what he was doing. So not exactly hauled over the coals, unfortunately. Bradley was told that he needed to carefully examine his management style so that the perceptions of other people were taken into account. Or at least that was the Vice-Chancellor's recollection of what was said. Bradley's own recollection was that he was simply given generalised advice rather than any direction. Unfortunately, when the matter came before the court, it wasn't possible for the judge to decide which version was more accurate, because no notes were taken of the meeting, nor was the discussion confirmed in writing subsequently. The court concluded that in order to satisfy its duty of care after the previous incident involving the co-worker Heather, the employer or the Vice-Chancellor on its behalf ought to have reprimanded Bradley in a way that highlighted he had wrongly criticised a co-employee without first checking the facts on which he based the criticism, and should have counselled him to check facts first before attributing fault. The counselling, the court believed, should have also highlighted that when reprimanding a more junior employee for good cause, he should do so calmly, rationally, and courteously, although with the full authority of his office. The court concluded that if he had been counselled in this way, Bradley would have tried to follow the instructions he was given. If Bradley had then acted as he had been counselled, he would have checked first with Walters as to why she was in the office during the alarm situation and what she was doing there. If he'd made these inquiries and learned the true facts, the court believed there was no reason to suspect he would have acted with the same loss of control and aggression. The lessons to be learned here are twofold. First, the employer failed to properly investigate the previous complaint against Bradley, apparently preferring instead to quietly pay out the affected employee and have an informal chat with him about his obligations as a supervisor. Secondly, this was compounded by the employer's very basic error of failing to document in writing the discussion with Bradley. Accurate notes of the conversation may potentially have supported the Vice-Chancellor's claim that Bradley was given a specific direction not to repeat similar behaviour in the future. That could have greatly assisted the university's defence. The next case involved a community care situation. It's called Gover versus Untitled Church. This case, the defendant was successful. Tony Gover was employed by Lifeline Community Care, which provided support services to people with a disability. She was employed as a disability worker based at their Ipswich office. One of the clients she supported was a woman who had an intellectual disability and exhibited what are described in the industry as challenging behaviours. This woman was called Tara. As a result of these challenging behaviours, Tara's support needs were shared between multiple carers, 8 regular staff and others who filled in. A person identified only by the initials MD in the judgment was one of the other support workers. Apparently, she was referred to as MD at trial in order to protect her anonymity due to the nature of the allegations that Ms. Gover made against her. Gover believed that she had a good relationship with her co-workers. However, after she had been working at Tara's house for about 10 months, during a changeover, she was violently attacked by MD. During this attack, she feared she would die. She suffered physical and psychiatric injuries, escaped by car, and was hospitalized. This incident occurred in December 2009. 2 months earlier, in October 2009, she had handed a letter to her supervisor setting out a number of complaints she had about MD's behaviour, including the following statements. 1, I perceive her behaviour towards me as aggressive, unpredictable, and even narcissistic. 2, I do not wish to be placed in any position where I may cross paths with her during a shift changeover. 3, I wish to request not to work with or near her because her behaviour frightens me. 4, over the past few months, I have been harassed by her in my workplace. Now, this letter contained nothing to suggest that there had been any actual or threatened physical violence on the part of MD. Instead, what the letter recorded were various acts of emotional aggression. The only physical aggression mentioned in the letter was what had taken place at a meeting where the supervisor was already present and already knew about it, in which MD had engaged in finger pointing, accompanied with a raised, angry voice. After meeting with MD and Gover together, the supervisor spoke to MD separately, and she agreed to try and get along with Gover. Further, the supervisor changed the rosters to reduce the number of crossovers between them at shift changes. However, these were not eliminated altogether. Still, roster records produced at trial show that Gover and MD had crossed shifts at Tara's house on 8 separate occasions between the date in October when she gave the complaint letter to her supervisor and December when the assault occurred. Despite these crossovers, there was no evidence of any altercation between them and no further complaints made after the letter. The court accepted in these circumstances it was reasonable for the employer to draw the inference that Gover's original concerns had abated somewhat. Gover argued that after her original complaint, MD should have been reprimanded or counselled. She relied specifically on the Walters decision, arguing that intervention by the employer at this time was likely to have prevented MD's behaviour from escalating. However, the court was not persuaded by this argument. Walters was not a case in which an employee had irrationally assaulted a co-worker. The judge in Walters accepted that the supervisor, Bradley, was likely to have tried to comply with instructions given to improve his management style. There was no basis for a comparable finding to be made in this case. If MD had given any rational thought to her behaviour, she must have known that violently assaulting a co-worker would result in instant dismissal. It was hard to see that any counselling or reprimand given 6 weeks earlier was likely to have resulted in any different outcome. So what are the learnings from this case? As in the case of Walters, you had a relatively informal response by the employer to a written complaint against a co-worker. There were significant differences, however. In Walters, the prior incident which resulted in the complaint involved a serious psychological injury being suffered by another employee who had left the organisation. This justified a more formalised response which the employer failed to take. In the Gover case, while the complaint letter nominated multiple episodes of concerning behaviour, they were all very petty in nature. The measures taken of adjusting rosters and informally counselling MD were proportionate to the seriousness of Gover's complaint. No doubt if she had raised more serious allegations, these measures on their own are unlikely to have been a sufficient response. The final case I'll cover is Swan and Monash Law Cooperative, a Victorian case in which the plaintiff was successful. The employer was a non-profit organisation that operated a specialist law book shop from the basement of the law building at Monash University in Melbourne. It was operated by a board of directors comprising current and former students at the university. The co-op employed a small number of staff, including a manager, Mr. Cowell. Wendy Swan started working at the shop as a retail sales assistant in July 2002. When interviewed for the position, Swan was told that she would be working side by side with the manager, who would run the business as directed by the board. Although she never aspired to be the de facto manager, Swan understood that the board was open to suggestions from her about the way the bookroom was run. Unfortunately, as time went on, Cowell perceived that she was meddling in management decisions. By the first semester of 2003, the board learned of friction between them. Specifically, Swan reported to the chairman that Cowell's behaviour was very strange. On one occasion, he threw a book at her. On another occasion, it was a calculator that was thrown. She described him as moody, which sounds like an understatement. The chairman reported back to the board that Swan had made this complaint. The board's minutes noted that the board may be vicariously liable for Cowell's behaviour and that this could include workover claims. So clearly the law students and lawyers on the board were at least paying attention to their legal risks. The chairman then met with Swan to discuss her concerns. She said that she had told Cowell herself that she didn't appreciate him running her down all the time, and since then he had been more courteous and easier to work with. Relieved, the chairman asked if she wanted the board to pursue disciplinary action or, wink wink, just take her comments on notice at this stage. She said, just take it on notice. After this, the board made no further inquiries. They concluded there was no need to take any formal steps against Cowell, such as a formal warning or an investigation into his conduct. Instead, the board resolved to monitor the situation by ongoing dialogue with both staff members individually at regular intervals. It also resolved to put in place formal position descriptions for the employees and workplace behaviour policies. Great. None of these things were done. There were no discussions with Cowell, informal or otherwise, regarding the board's expectations for his behaviour. The court observed that the lack of action may be explained, though not excused, by the fact that all members of the board were unpaid volunteers. However, as the board recognised in their own minutes, they're all well aware of the risk of damage to their employee and/or potential breaches of the employer's workplace health and safety obligations. Now, in April 2005, you'll recall that's 2 years after problems were first reported, Swan advised the board that tensions had re-emerged with Cowell. During a particularly busy period, he'd been speaking angrily and aggressively with her and other employees. She'd seen him make another employee cry. The board told her they would implement policies to make things work better. Specifically, they would put in place contracts to clarify the workers' roles and responsibilities, Guess what? No contracts or workplace policies were put in place. Then another 18 months, 2 years goes by. In July 2007, during another busy period, things came to a head. There was an episode of major conflict between Carol and Swan. She left the workplace in a distressed state, complaining of workplace bullying. Carol rang the chairman. He admitted things had gotten out of hand and he had responded inappropriately. Now, the court looked at the evidence about Carol's behaviour. The judge described that he had a conservative, untrained management style and an unwillingness to accept Swan as a colleague. The court held that over the period from 2002 to 2007, he'd engaged in an established pattern of workplace bullying. Although the pattern of behaviour was episodic, and after 2003, not characterised by explicit incidents of occupational violence, his conduct characterised the work environment as one in which the plaintiff was subject to stress, emotional distress, humiliation, belittling conduct, intimidation, and aggressive managerial direction. The employer tried to argue that Swan coped with Carol's behaviour and never complained with distress or other symptoms that might warn them of the possibility of psychiatric injury. They also argued it would have been a breach of privacy for the board to speak with Carol about his conduct after Swan had asked them not to do so. These arguments were rejected by the court. The board itself acknowledged that her report back in 2003 involved allegations of bullying. This was not ordinary workplace stress that was an inevitable part of performing her agreed duties. Second, the risk of psychiatric harm from bullying is well understood and was recognised specifically by the board in its own minutes. Third, Swan was offered only two options in response to her original complaint, namely a choice between a formal warning to Carol and doing nothing at all. This didn't rule out the board speaking informally to Carol about his behaviour. Further, her so-called choice was made in the context of the board giving her assurances about actions that they ultimately failed to deliver. Finally, as an employer, the board had a positive obligation to actively consider amelioration of a risk of injury. This could not be delegated to the worker herself. So summing up, the judge considered that based on the complaint she'd made in March 2003, the board was under a duty to take action. Its ongoing failures thereafter to put in place proper job descriptions, employment contracts, and workplace behaviour policies amounted to a breach of the employer's duty of care. A reasonable employer should have investigated what was going on in the bookroom, potentially engaged a mediator to work with the parties. There was no formal system in place enabling workers to obtain assistance if they experienced bullying. Because the behaviour had been allowed to persist for so long, it was easy for the court to conclude that early intervention by the employer was likely to have avoided the injury. The primary learnings from this case are twofold. Number one, while it's not expected to have the same resources as a large corporate or government workplace, even a small non-profit employer will be expected to have at least some systems in place to address issues of workplace behaviour. Secondly, if an employee is experiencing workplace bullying, the fact that they don't insist on the perpetrator receiving some formal warning does not absolve the employer from taking other actions to minimise the risk of the behaviour being repeated. That's all we've got to say about the cases. I hope that's been illuminating. I'll just hand you back to Hannah for some final matters.
Thanks, Andrew. Look, time for just two questions, and I think one of them is going to back onto your second lesson learned from the Swan case. But basically, in a situation, a worker may report that they have been bullied or harassed by a co-worker, but sometimes they ask for no action to be taken at this point in time and just want the manager to know that there has been an allegation of bullying and harassment there. What would your advice be to an employer in regards to how to balance such a request coming from a worker with also the employee's duty of care owed to that worker to protect them?
I think the thing there is an employee doesn't tell you these things for no reason. They don't tell you and expect you to do nothing. They may not wish for there be something formal on the bully's employment file, They may not wish for formal action to be taken, but the mere fact they're coming to you means you need to do something. It may be the fact that you talk to the employee and then look at and assess the alleged bully's conduct. You may take a greater interest in their performance. It may be that you don't specifically raise the issue with them, but you just engage in some more close supervision and analysis of their conduct, and you record what you have done and you follow up on it later. After a significant period of time, when you've done those things, you go back to the employee who made the complaint, have things improved.
And I guess adding to what you're saying, Ed, it just sort of illustrates the importance of, number one, having policies in place on how to manage behaviour and how to respond to complaints, and secondly, making sure that you follow your own policies.
Good answers. The second question, and I guess in these cases we are focusing on the worker that has been bullied and or harassed. What advice do you give to employers in terms of, because they also have a duty of care owed to the perpetrator that's been alleged to have been doing the bullying and harassment. So I guess this is a really difficult situation for an employer, because not only do they have to care for the potential victim, but also they still owe a duty to the employer, to the employee that has been alleged to have been doing the bullying and harassment. Do you have any advice to them?
Certainly. Look, there's a line of authority that suggests that you will not owe a duty of care when undertaking disciplinary and investigative procedures. Now, that line, there's certain exceptions to that, but the cases certainly make it clear that undertaking appropriate investigations in an appropriate way will not be bullying. An employer certainly has a duty. Let me rephrase that. An employer is entitled and obligated to take action to investigate these claims. And of course, it's reasonable to suspect that undertaking those investigations may cause the alleged perpetrator some stress. So what you'd need to do then is to say, well, the fact that it will cause you stress doesn't mean we're not obliged to undertake the investigations. What we're obliged to do is to help you manage your stress while we undertake those investigations. So that may be referring the employee to the appropriate counselling service or psychological first aid process that you have in place, and providing them with some support so that they know that it is an impartial process and it will be managed impartially, and that they have support while it's being undertaken.
And hopefully that process is documented somewhere in his policies.
Exactly right. No, it just once again, it reinforces the need to have processes in place. So you're not trying to deal with these situations on the fly. You're dealing with with individual sensitivities and vulnerabilities, potentially on both sides of the situation. And if you're just trying to make it up as you go along, the chances are very good that you're going to run into problems.
Yeah, I guess the other point I just wanted to touch on quickly is that with these policies and procedures with how to manage bullying and harassment in the workplace, they should probably be revisited every now and then and reviewed, right? Just
certainly
to keep up to date with the latest case law, legislation and things like that. The court's interested to know that employers are continually learning from.
They are often, particularly in cases of psychiatric injury, a court will want to know that the employer understands what the best practice is and has made an effort to keep up to date with what best practice is. No system is perfect, but if you can call evidence to show the court that you have these things reviewed and your understanding of best practice is X and you improve your system over time, that's very good evidence.
Yeah, that's great advice. Okay, everyone, that's a wrap for today. A big thank you to Ed and Andrew for presenting. We appreciate the time and effort you both put into preparing and presenting on today's topic. And to our audience, thank you again for tuning in this morning. We hope you found this session informative. As mentioned earlier, this will be recorded and sent out to you hopefully early next week. And again, you'll find it on our YouTube channel once uploaded. That's all from us here today at WorkCover Queensland. Please keep an eye out for the details of our next webinar, which will be published soon. Thank you, stay safe and have a great rest of your day.